Okay. Welcome to the Labor and Workforce Continuing Education Series. My name is Matt Piesold, and I'm a Labor and Workforce Specialist located in Kansas City. This webinar series represents an outgrowth of past collaboration between MU Extension, Labor and Workforce Development, and the Department of Labor. It is a great honor today to welcome Kathy Robinson, JD, from the Department of Labor. Over the course of the next 2 months, we will offer a series of webinars that will help you prepare for the upcoming complications in navigating the system and employment obligations. Today, I also want to inform you that this presentation will be recorded, but will be stopped for the question and answer section. Please post your questions in the chat feature or save your questions till the end of the presentation. I would now like to turn it over to Kathy to introduce herself.
Good morning. My name is Kathy Robinson, and I am a benefits advisor with the U.S. Department of Labor Employee Benefits Security Administration. And our agency has jurisdiction over ERISA, which stands for Employee Retirement Income Security Act, and the laws that that amends it, such as the Affordable Care Act or the Mental Health Parity and Addiction Equity Act. And so we're going to talk today about tips and tools for administration of group health plans that are subject to ERISA and COBRA, federal COBRA, which we'll talk a little bit more about what that is in a little while, for busy employers and people who deal with plans. It's my pleasure to be here today, and I thank you very much for taking time out of your busy schedules. And I know you have many, many other important things to do, so I hope that you find this valuable and a good use of your time and resources. I have been with the Department of Labor as a benefits advisor for 12 years. And I've been an attorney for 25 years and a mediator for 24 years. And I find all of that background very helpful with the work that I do as a benefits advisor with the Department of Labor. What a benefits advisor does is basically our job can be divided into 2 separate categories, or maybe 3 categories, but for today's purposes, I'll say 2 categories. One is to do outreach such as this presentation. And so if you are affiliated with a nonprofit that would like for me or someone from my office to come in and do a presentation of one of the presentations we provide related to ERISA or a topic that we provide, feel free to call me, and I would be happy to discuss that with you and hopefully be able to set something up. We have a number for our agency that's at the end of the presentation, but I'll go ahead and give you my personal contact information. So as you know, my name is Kathy Robinson. It's on the first slide here for the spelling, but my direct dial phone number is 816-285-1874. Again, 816-285-1874. But if you call me, please reference how it is that you know me, because I talk to lots and lots and lots of different people in lots of different capacities. Also, my email address is robinson.kathyj@DOL, as in departmentoflabor.gov. So you're welcome to email me also with regards to presentation purposes. But the other half that what a benefits advisor does is that we staff a toll-free line, and that number is 866-444-3272, and that's also at the end of the presentation information. And we enter phones. There are 10 of us in the Kansas City regional office. We have many offices across the country, but we answer the phone between 8 and 4:15 Monday through Friday Central Time. And 10 of us cover 11 different states. But people from other states sometimes get in our office phone queue, and we certainly are happy to answer their calls. Or if you need to call before 8 a.m. or after 4:15, we have offices on either coast that are probably still open, or maybe we're not open yet, so they may be open before we are, that you can ask a question if you need something answered right away. We also have a possibility of being able to file a web inquiry on our website, to where a benefits advisor will look into your information and get back to you. So it's helpful to know what a benefits advisor does and how to get a hold of me if you have specific questions or issues that arise in the future that maybe you don't think of today. One of the things that I like to say when I give a presentation is who I was thinking of as the audience as I determined what to include in the presentation. And for today's purposes, I was thinking that it's probably not going to be for people who have many years of experience and who hire a lot of outside help and have their own service provider experts with regards to some of these issues. I'm anticipating that it might be, a lot of smaller employers or people who wear many hats. For instance, of course, large employers are going to have maybe one COBRA person or more than one COBRA person at the employer and hire maybe a service provider, third-party administrator to handle COBRA. A small employer, one person might be handling all of the employee benefit plans under ERISA, the group health plan, the COBRA, the flexible spending account, the health reimbursement account, maybe the pension plan, or what have you. So I'm anticipating that it's probably going to be for the smaller employees or people who are new to ERISA or having something to do with a responsibility related to group health plan coverage or COBRA and or COBRA compliance. And letting you know some things that I think are helpful for people to know, both for you and the employees that you work with. As well as some resources that are available to you and how to go about finding those resources and knowing about them. And the other thing is that I really appreciate those people who are attending more than one presentation. And I can't help that there is occasionally a little bit of overlap between different presentations. For instance, today is tips and tools. And so we've done a COBRA compliance presentation. We're going to do a fiduciary duties for group health plan presentation. And so some of the information will be covered there as we specifically devote entire presentations to those particular categories. But today is about tips and tools. Along those lines, I'd also like to encourage you to visit, to visit or attend upcoming presentations that we have. Next week on August 26th, Leandra Dodd Arnold, our Senior Technical Advisor for Health Issues, will be doing a presentation on the Mental Health Parity and Addiction Equity Act. And on September 3rd, Cynthia Smith with our office, a benefits advisor also, will be doing a presentation on fiduciary duties for group health plans. And on September 10th, I'll be doing another presentation on fiduciary duties specifically for retirement plans. Okay, so let's go ahead and get started. One of the other things that I wanted to say is that we've all heard about red tape at the federal government, and that's certainly not a myth. One of the rules that I work under is that we can only use pre-approved slides, and we can't really develop our own slides, if you will. So I have taken some slides that have already been developed. And in addition to that, there are a couple of resource tools or lists that I provided for you as a part of this presentation. But probably the majority of the tips and tools that I'm going to share today aren't on a slide because we don't have pre-approved slides available for them. So I'm not able to provide them in terms of written materials for you, and I apologize for that. But I'll try to be as clear as I can with helping you understand what I'm talking about and know where to find the information that I'm talking about on our website. Okay, so on the first thing, tip and tool that I want to go over is that EBSA, which stands for the agency that I work for, Employee Benefit Security Administration, Part 7 basically applies to group health plans and rules related to group health plans. And on our website, we have a compliance tool to help evaluate whether or not you are in compliance with your group health plan. It summarizes the regulations and other guidance that we use or that we issue for group health plans, and so that you can implement applicable provisions of what we call Part 7. And basically Part 7 is Part 7 of Title I of ERISA, which includes some of the, we have jurisdiction over Title I of ERISA, and Part 7 is part of Title I. But basically, when we say Part 7, what you think is group health plan rules and regulations. And that compliance tool provides detailed examples and tips to help plan sponsors review what you do to help you be in compliance with the law. And I want to tell you how to find that on our website. And on the last page of the presentation, it talks about our website, and it gives you our website, but I'm going to go ahead and give you our website also. It's www, of course, .dol, as in Department of Labor, / agencies, which is plural, / and then the acronym for our agency, EBSA. So dol.gov / agencies / EBSA. And what I do is in the search box, I just put in Part 7 compliance tool. And what that will bring up, what you're looking for, is something called the Compliance Assistance Guide, Appendix A, Self-Compliance Tools. And so that can help you look at your compliance with regards to the plan. Other places to look to ensure that you're in compliance. One place is the summary plan description. And there's a couple things to be aware of with regards to the summary plan description. First, I hope, and might even say assume, that you know what a summary plan description is, but just for completeness purposes, I'm going to explain that the summary plan description is the written document that outlines what is covered under the plan, eligibility, rules, and also meets the statutory requirements that need to be in a summary plan description, such as an address at which a plan administrator can be located if a participant has a question or needs to notify the plan administrator of certain things. Of course, the summary plan description, meaning the plan rules, should talk about some of the operation issues related to the plan. And of course, it must comply with ERISA. But one thing to keep in mind is that there are only certain things that ERISA requires to be in a summary plan description and that a plan cover. And beyond what is required by ERISA for a summary plan description to have in it or for a plan to cover, it is up to the plan to determine how the plan is administered and what is included in the summary plan description. Of course, the more information that you can provide to help people navigate what their benefits are and what is included, and most importantly, what's not included, the more helpful it is for everybody involved. So a summary plan description and the plan rules cannot be statutorily inconsistent with ERISA. But to the extent that ERISA or a law that amends ERISA, such as the Affordable Care Act or the Mental Health Parity and Addiction Equity Act and a whole slew of other laws, the plan is free to handle things as it sees fit, so long as it treats people the same. So make sure your summary plan description and your plan rules are not inconsistent with ERISA. And then beyond what is required by ERISA, the plan pretty much gets to determine what it covers, what it doesn't cover, how it handles certain situations, or certain situations that it's not going to allow for benefits or coverage or eligibility or what have you. But one thing that's important to keep in mind is that similarly situated individuals should be treated the same. So of course there are non-discrimination provisions, such as you can't discriminate on the basis of a health factor. So you can't say, I'm going to charge you more because you have diabetes or you have cancer. But a plan can say, I don't cover this specific treatment for AIDS, for instance, even though recently someone, perhaps the only person under the plan, started receiving AIDS treatment and that specific medication that's not being included. So, but all people with AIDS, all people with medication, that medication need to be treated the same. So similarly situated individuals need to be treated the same. Okay, so start with the summary plan description and know what it says and follow it. You would be surprised how often I call people related to the plan with the employer, where the employer is not only, the person that I'm dealing with is not only not aware of what the summary plan's description says, which is basically saying this is how the plan operates, but they also are acting directly inconsistent with what it says. But also look at other plan documents. It's kind of self-explanatory, but the summary plan description is basically a summary of the full plan document that outlines everything that the plan covers, all of the plan rules, etc. You can also look at wellness program materials if your employer offers wellness programs. Now, one thing to just kind of keep in mind is that there are distinctions between wellness programs related to group health plans, which are encompassed under ERISA, and other wellness programs that the employer might offer that don't have anything to do with the group health plan itself, and that's not subject to the rules of ERISA. You can look at the certificates of coverage or evidence of coverage that the insurance carrier provides. You can look at the summary of benefits and coverage that is mandated under the Affordable Care Act, or the summary of material modifications where the plan has been changed, but there's not necessarily an entirely new summary plan description or plan. It's just that there's been some material modifications, or collective bargaining agreements, or service provider contracts. With regards to service provider contracts, one thing to keep in mind is that what we tell employers are basically one of the things that I just said to you, which is anything not required or that is not allowed by ERISA, pretty much the employer can do something else. However, sometimes the employer is limited by a contract that they have with a plan administrator or with an insurance company. So for instance, say there's a circumstance where this person has this very compelling reason why they did not why the participant did not sign up in a timely fashion for COBRA. Perhaps they were in a coma or something like that. Well, the employer may say, gosh, you know, that's a pretty reasonable reason why you could not timely elect COBRA or make your payment on time. I want to let you back onto COBRA. Obviously, if you were in a coma, you need the coverage. But if the contract with the insurance carrier or the plan administrator says we don't allow the employer to exercise the discretion to allow people on COBRA who have missed their deadlines, then that would definitely be something that you'd have to honor. And so if we call you to discuss a situation with you, one of the places that you would need to look to determine what you could do or where the discretion could be exercised would be, are there any limitations on what you can do other than ERISA, such as the service provider contract? You can also look at the Form 5500 and financial statements related to the group health plan. And the Form 5500 is the reporting document that's required annually for most plans with the Department of Labor and in some circumstances, the IRS. And we'll talk a little bit more about that in a little while. Look at your claims processing policies and procedures. And if you are a fully insured plan, you'd want to know what those are with the carrier. And if you're a self-insured plan, you'd want to check with your internal plan administrator policies and procedures. And we're going to review what a self-insured plan and a fully insured plan are and what the difference is between them and why it's important. And then, of course, you can look at your audit reports to get more information. So work to ensure that the plan is in compliance both as documented and in operation. And I'm going to talk a little bit more fully about documentation in a little while, but it's very important that you operate according to the rules that you have in place. And there may also be like an employee handbook or employer policies that are written, and we recommend that the policies be written, and that the employer follow the policies and the summary plan description that they have, and that the documentation not just be something where that the documentation is something that actually occurred. And I'm not saying that you would make something up. What I'm saying is sometimes people try to do like automatic documentation, whether or not something happened. And so documentation should be either at the same time of something happening or soon after something happens. Certainly not before something happens, that something did happen. And you can document that something will happen, but you can't document that something has happened that you anticipate will happen. And we'll talk a little bit more, like I said, about documentation in a few minutes. And then if you have questions or concerns, you can contact EBSA. And our number is on the last slide. You can talk to a benefits advisor. And there's also sometimes people that you can call within EBSA, and a little bit of information about that is on the last slide as well. Okay, one of the things that I recommend that you do, if you want to stay, I mean, the law changes all the time. Just last night, as I was preparing for this presentation, I noticed that there was a rule that a rule change that I was not aware of. And I am subscribed to the website. And of course, I should be aware of all new rules. And I was thinking, how on earth is it possible that this happened and I was not aware of this? But subscribing to our website will let you know when updates occur, and you can spend a tiny amount of time just kind of looking at it and saying that's something that probably doesn't apply to me, I'm not going to worry about it, or ooh, this is a big deal, it could substantially affect my work, I want to look at it more closely, and thank goodness I know about this so that I can be compliant with the law and know about my job. There's also the IRS website. Some things are within our jurisdiction, some things are not within our jurisdiction, but the IRS also has helpful information related to different things. For instance, they have jurisdiction over health savings accounts, high deductible plans with health savings accounts, but we do not. There's also, like regarding the Affordable Care Act, the Health and Human Services website, which is healthcare.gov for marketplace or exchange plans. Okay. Some resources that are available to you. For compliance assistance for health plans, there's a link that you can go to for specific administration information, specifics regarding the Affordable Care Act. We're going to touch on the Affordable Care Act today, but just a little bit. So that is much more specific about the Affordable Care Act. The Mental Health and Substance Use Disorder Parity Act, we're going to talk a little bit more about, also just a very tiny little bit more about that. But basically, that gets pretty technical if you start to look at the details and have to look at the minutia in order to make a determination as to whether a provision in a plan is in parity between mental health and substance use disorder benefits and medical surgical benefits. And so it can be very helpful to know that that resource is available to you. And like I said before, subscribe for updates. There's our website, and you can go on that website. Not only it's chock full of lots and lots of information, you could spend a lot of time there. I spend a lot of time there. Hopefully you won't have to spend too much time there, but I do think you'll find it helpful. Excuse me. If you would like to file a web inquiry for a benefits advisor's assistance, like for instance, if you have documents to be looked at or that's quite technical or something like that, that's difficult to explain over the phone, then you're welcome to file a web inquiry as opposed to calling our toll-free line, which is the next bullet point. And then also, if you have like pretty technical or difficult Part 7 questions related to group health plans, then you can call OPSCA, and there's a phone number available for them, or you can contact a benefits advisor, and we might be able to be helpful with that. The other things that I'm going to talk about, these are some other tips and tools that I don't have on slides. So one of the things that I've already talked about is that for every employer plan under ERISA, there should be a written document. That would be the plan document. And then there would be a summary plan description that should be available for participants. And there are rules related to making them available and disclosing it to them. But like I said before, it's very important that you are familiar with the summary plan description. For every single employer plan subject to ERISA that you have, that any part of your job touches on, I recommend that you read the summary plan description, and in fact, preferably have a written copy of it available to you, either via the web or a printed hard copy. And then also, as a participant, maybe your job involves doing COBRA or doing something related to the group health plan, but you happen to also be a participant in the 401k plan or the other retirement plan. Get a summary plan description of every employer-sponsored employee benefits plan that you are a participant in, and read that also. I read my summary plan description for my health plan word for word every year, and I make my daughter do so also, or at least I did when she was younger. Excuse me. While she was still in college, I was able to require her to read it every year. Now I just remind her to, and whether or not she does, I don't know. I think she relies on me just like traffic tickets. Her mom's an attorney. I think she kind of relies on me for the health questions that she has. But I don't read her summary plan description, so it's very important that she do so. A couple of years ago, it ended up being pretty helpful that I read the summary plan description. One of the things to know is that they can change significantly from year to year, and they will change significantly when an employer changes carriers, and things may be done differently. If you work with a new carrier, then don't expect that they handle things necessarily the same way. And they may have, there may be a whole new set of rules and mores that you need to learn to deal with. But make sure you read the summary plan description. The thing that happened to me a few years ago was I see different doctors for different things. Different doctors order lab work. And there was a new and different plan provision that said, we will only pay for lab work once a year. And so I used to just, whatever doctor needed lab work, they would just order whatever they needed. And so I had them all get together, and I said, okay, what lab work are you guys going to need this year? It all needs to go into one order to make sure that it's covered, because we're only going to do this once this year. And then the next year, that provision was not in the plan, and it hasn't been in the plan since. So I'm not sure what that was about. But that would have been quite a surprise and probably quite expensive if I had not read the entire summary plan description as I do every year. Now, I've been, like I said, with EBSA for 12 years. I've had the exact same plan for 12 years. Actually, I do Blue Cross and Blue Shield Federal Basic Plan. So when I say exact same plan, I mean exact same title. Obviously, the provisions of the plan change sometimes on a yearly basis. So it's important to know what the summary plan description says. And I would encourage you to make sure that the participants are aware of what a summary plan description is, meaning the employees that participate in the plan, and that you're required to make sure they have a copy of it, but to encourage them to read it. Because the more they take responsibility and learn how these things work on their own, hopefully that saves you some time in terms of having to walk walk them through all kinds of things that they're not necessarily familiar with. A lot of that depends on the sophistication of your workforce. Some workforces, the people are very experienced and very sophisticated with group health plans and how they work. Even in those kinds of workforces, perhaps it's a situation where it's someone's first time ever having health insurance and they don't know how it works. And so there's the full gamut of people that you might come across in terms of their level of experience and sophistication, and the ease of which it makes your job to try to deal with them. But I think the more educated they are and the better they understand things and the more familiar they are with things, it just makes your job easier in terms of them bringing issues or concerns to you. So I recommend that. Okay. Another tip is to determine whether you are a fiduciary and why it matters for liability purposes. And to know that this can change over time if your duties change, even if your job title doesn't change. So for instance, I mentioned that on September 9th and September 10th, we're doing programs on fiduciary duties for group health plans and fiduciary duties for retirement plans. And there is, as you might expect at this point, some overlap between those, but there are also some specifics that are only applicable to those particular kinds of plans. So under ERISA, whether or not someone is a fiduciary is not dependent on a title necessarily. The plan sponsor will be a fiduciary, but basically it's a definition, and it's if someone gives an investment advice, which is not going to apply to a group health plan or COBRA, but if someone exercises authority or discretion over plan assets. And so if you just withhold the contributions and deposit them into the bank and do the paperwork with regards to that, you're not going to be a fiduciary. You're basically fulfilling a clerical task. But if you have discretion or authority over what happens to plan assets, then you would be a fiduciary. And so if your job changes over time, you might all of a sudden become a fiduciary. And it's important for you to be aware of that, because fiduciary obligations under the law are some of the highest obligations legally that people can be held to. And there can be significant liability, sometimes personal liability, for breach of fiduciary duty. So it's important for you to determine if you're a fiduciary or not. And to realize if your duties change, that you could become a fiduciary, and especially under COVID, as some people are leaving positions, some employers are downsizing, sometimes quite significantly, you may be taking on duties that you never expected to take on, and you might become a fiduciary. So be open to that and aware of that situation. Okay. And then depending on the size of the employer, I recommend that at least one person at the employer should know all of the responsibilities that are incurred under the plan, and who is responsible to do what, both within the employer and also anything that is outsourced to a third-party administrator or to a service provider. At least one person, preferably more than one, needs to know who is responsible for what. And have a plan in place to make sure that duties and responsibilities are met if someone responsible for an obligation to the plan can't do so either temporarily or permanently. Permanently is kind of easy. It's at least easy to determine if they don't work there anymore. But it's not necessarily easy to predict, because something like COVID might happen, and all of a sudden your job, your employer, your customer base changes so significantly that people are let go, or they leave for whatever reason, or, God forbid, they get sick. But sometimes, they give you advance notice, and and then temporary, maybe they're pregnant, and you can have lots of advance notice that they're going to be gone for a period of time and how long they anticipate being gone. Or perhaps it's something sudden that no one could predict, and they're gone temporarily. So have a plan in place to make sure the duties and responsibilities are met if someone responsible can't do so temporarily and permanently. And the fewer people there are to take care of all of the employer plans, the more difficult it is to do if they're not able to do their job. So if there are 3 different COBRA people, then usually it's a lot easier to get someone's duty covered. If one person handles the COBRA, the group health plan, the retirement plans, flexible spending, life insurance, etc., and that person leaves temporarily or permanently, unexpectedly, that can be quite concerning for the employer. But if you have service providers where you've outsourced some of the responsibilities related to an employee benefits plan, make sure that you monitor the service providers, that you're aware of what they're supposed to be doing for you, and that they're actually doing what they're supposed to be doing. Sometimes we call an employer if we're doing some informal dispute resolution on behalf of a participant. We don't necessarily call the third-party administrator or the carrier. We're often as likely to call, if not more likely, depending on the circumstances, the employer. And what we don't like to hear is, oh, I don't know anything about that. We outsource that. We have a third-party administrator that handles that. Well, you do need to know about that, or someone needs to know about that. And then it may be a circumstance where they've done the appropriate thing and you just need to look into that and find that out. Or perhaps they haven't done the appropriate thing. And so when that happens, we try to get the issue resolved, but then we also look into it further in terms of, is this some kind of a plan-wide issue? What caused this? Does it need to be fixed? Is there any kind of a systemic issue between the employer and the third-party administrator with the third-party administrator that needs to be addressed? But really, the employer should be on top of those things. And if you are getting feedback from an employee that the service provider isn't doing what they're supposed to be doing, then that's something that needs to be addressed and taken care of promptly. Now, one of the things that I'll acknowledge is that it can be difficult to determine if you're not really familiar with the law or what's required, whether or not a third-party administrator is acting inappropriately. For instance, the employer is supposed to notify the third-party administrator for a COBRA notice, and a COBRA notice is supposed to be mailed out to a participant within 44 days of the later of the job ending or the insurance ending. But the employee may think, I'm supposed to get that as soon as my job ends or as soon as my insurance ends. And so just because the employee has determined that they don't think it's reasonable that they haven't received something doesn't mean that you or the third-party administrator is not in compliance with the law. But obviously in the situation of the example I just gave, we would educate the participant if it's not been 44 days yet, and would only call the employer to request a COBRA notice for them if it's maybe a situation where we're requesting that the employer provide one right away or as soon as possible because of a medical situation or a compelling need to do so. And even in that circumstance, we make a request as opposed to requiring an employer to do that. Okay. But you do need to monitor your service providers to make sure they're doing what they're supposed to be doing. And then one other thing to keep in mind is very often, I mean, it's not really funny, but it's amazing how often this comes up. People will call me and they will be distraught and wanting to report how terrible the third-party administrator was or the carrier was with regards to customer service. And one of the things that I explain to people is that there really aren't any legal requirements with regards to how helpful or professional or courteous or organized or what have you along those lines that third-party administrators be or carriers in terms of how long you wait for them to answer a call or anything like that. The customer is the employer. to some extent, I guess one could make an argument that the customer is the participant, but often third-party administrators and carriers are not particularly interested in making sure, you know, fulfilling the needs of the participant and making sure they're satisfied, if you will. Very often they do the least required to deal with the situation immediately in front of them. And what I would encourage you to do is be aware of that and not necessarily act that way yourself. If you're the employer, if you, or the person working for the employer, if you have discretion over who the employer chooses as their third-party administrator or carrier, then that might be one of the things you talk about in terms of how well customers are treated, and address that in certain ways. Okay. And then I recommend that people cross-train as much as possible in case people are unexpectedly temporarily or permanently gone from their positions. And I recommend that you know when and how to call a benefits advisor and when to suggest that an employee do so. For instance, if one of the times that you might call a benefits advisor is, say you've looked at our website and you've looked at the publications and you've tried to find the answer to your question and you haven't been able to find it. That might be a time to call a benefits advisor. Or if you have a new situation that you haven't dealt with and you want to make sure that the way that you are dealing with it is compliant with the law. Or if the employee has not done something that they were supposed to do and perhaps it was outlined for them in the summary plan description, or they did not do something timely, like perhaps, excuse me, elect or pay the COBRA premium. You've explained it to them, but they're not taking no for an answer. You can have them call a benefits advisor and we'd be happy to explain to them what the law is with regards to that. If you're a fiduciary, document important decisions made and the process used to determine prudence. Fiduciaries are required to make prudent decisions with regards to the employee benefit plans under ERISA. But the way that prudence is looked at and evaluated, one of the ways by the Department of Labor is the process that you use to determine that you made a prudent decision. And then of course, keep the documentation that you create to show the process that you used and how it is that you came to a prudent decision. But otherwise, keep good documentation regarding anything else that's important that isn't necessarily a fiduciary decision. For instance, if you're required to provide COBRA notices within 44 days, document what you did, that you sent it to so-and-so at their last known address on such and such a date and who did it, so that you have that information available to you. Some people even keep a copy of the COBRA notice that they sent. And you can determine to some degree what information that how long you want to keep it. Probably a good rule of thumb, there's some documentation that you have to keep 6 years plus current year, but a good rule of thumb would probably be at least 3 years. But document who did what, when. Another thing is read the uniform glossary of that's available for group health plan terms and be familiar with the terms, especially those that participants sometimes struggle with. Specifically, examples like the out-of-pocket maximum. Sometimes they don't understand that out-of-pocket maximum does not mean every penny that you've paid towards your health care, including things not covered by the plan or beyond an allowed amount. So know what the out-of-pocket maximum definition is for your plan and be able to explain it to a participant who can easily get confused about that. Know things like pre-authorization does not mean that once a claim is incurred that it's going to be paid. claims are not determined until they are incurred in terms of whether or not the plan is going to pay for it. And so that can be quite dicey and tricky. So it's important for people to understand that pre-authorization, basically the way that I explain pre-authorization is, at first blush, if a plan looks at it, they don't have something that immediately jumps out at them that indicates that it's not going to be covered. So a pre-authorization does not necessarily tell you much, and it certainly does not tell you or the participant or the doctor that something is going to be covered. And so it's important that they understand what's going to be covered, and it's helpful if you know, and if the participants can be educated about the right questions to ask to see if something's going to be covered. And so that would include things like, does the plan cover it? Okay, but just because the plan covers it, that's not enough. Does it meet the criteria under which the plan will cover it? Sometimes it might be extremely limited criteria under which the plan covers something, but the participant sees, oh, the plan covers it, therefore it's going to cover it for me. And so it's important that they understand that. And you, as you experience these issues, can make determinations about how much time you want to spend where with participants to try to save yourself time in the long run as you deal with those issues. And sometimes they don't understand things like deductibles. So it's important that you understand that and that you can help them understand that. You can send them to us. If they read the summary plan description and the uniform glossary, that should help. Okay. If you're a small employer, know whether you are subject to federal COBRA or state continuation coverage for your state and how to determine that. I just want to say a word real quick about something that I just talked about, and that is that I said something a little bit earlier in terms of carriers don't necessarily, go out of their way to make sure that participants are fully informed when they call. And it's kind of it kind of makes sense. Because you can't spend 2 hours on the phone every time you have a phone call, making sure people completely understand everything. But carriers typically answer what they're asked. So if you don't ask the right questions, so for instance, if you say, is such and such covered, and they say yes, they're not telling you that they're going to cover it in your circumstances. They're also not going to tell you that's not the right question to ask, or that's not enough questions to ask. You then need to find out, what is the criteria necessary for it to be covered? Does my circumstances meet that criteria? And so know that administrators and carriers only answer what they're asked, and don't necessarily make sure people are fully informed about that. Know if your plan is self-insured or fully insured and the difference that that makes. Basically, a self-insured plan is that the employer pays the claims that are incurred out of the employer assets, or has set aside money in a trust to cover the claims. There might be a stop-loss policy. A carrier situation is where the employer, sometimes the employees, but the employer pays premiums to the carrier, who then takes responsibility to pay the claims and takes on the liability to pay the claims. So long as the employer has paid the premiums. But this can be, you can't always necessarily tell, because sometimes, like say it's Blue Cross and Blue Shield, you think, oh, there's a carrier, they must be fully insured. Well, it might be a self-insured plan that has hired Blue Cross and Blue Shield as the plan administrator to administer the claims for a self-insured plan. And then I started to say a minute ago, it's important to know if you're subject to federal COBRA or not. If you are subject to federal COBRA, which obviously would be us, the federal government, under ERISA, it would be private employers with 20 or more full-time employees or the equivalent part-time employees over half the business year the year before. So some employers are subject to COBRA right now, even though they have under 20 employees, even though they didn't have COVID last year, but because we determine who is eligible for COBRA, or what employee or plans are subject to COBRA, federal COBRA, based on that information for the previous year, then they may be subject to COBRA. And then those employers that aren't big enough to qualify for federal COBRA would then be obligated for state continuation coverage according to their state rules. One of the things that I want to also mention about why not only know if you're self-insured or fully insured, but also why it's significant. And that is that self-insured plans are only subject to the federal ERISA insurance law, while fully insured plans, where the carrier takes on the liability responsibility for the claims, are subject not only to the federal ERISA law that I'm talking about, but also to state insurance law. So people will say, under our state law, medical necessity, if it's medically necessary, a plan has to cover it, or whatever their individual state law may be. If it's a self-insured plan, they don't have to worry about what's required under the state insurance law. If it's a fully insured plan, they do. So there's definitely significant differences there. Some laws apply differently, even on a federal level, to self-insured plans and fully insured plans. So it's important to know whether the plan is fully insured or self-insured, and very helpful to indicate that in the summary plan description so that participants can know that also. Okay. One of the things that's also important to know is that the premiums withheld from employee pay as their contribution towards the group health plan are not business assets. They are plan assets. So in hard times or whenever, a business cannot borrow those funds for business purposes. They can only be used to pay the premiums in a timely basis for the group health plans. They're not employer assets, they're plan assets. So it's very important for employers to know that. Also, I wanted to let you know that we do have a Form 5500, as you recall from earlier. The Form 5500 is the reporting document to the Department of Labor and the IRS in some circumstances for some plans. We do have a 5500 help desk. Their phone number is 866-GO-EFAST. We call them EFAST. And the number is 866-463-3278. Okay, and then also it's important that you know that we have, if you make a big mistake, we have voluntary fiduciary correction programs for certain mistakes, and we also have delinquent filers correction programs if you don't file your Form 5500 on a timely basis, and information related to those on our website. And we also have information in some of the materials that I'm providing today. And so let's talk a little bit about the materials that I'm providing today. Okay. So the first one is the Retirement Plan Compliance Assistance Seminar resource list. And I apologize, a lot of these are related to pension plans. So you may or may not deal with pension plans also, but a lot of these are just helpful for fiduciary information in general, or specifically to group health plans. So as you look at that, the fiduciary education campaign is helpful. Meeting your fiduciary responsibilities, tips for selecting and monitoring service providers for your employee benefit plan, tips for plan fiduciaries, and then a lot of it is just pension plans. The other thing that's helpful in here besides pension plan is selecting an auditor, and then also with regards to fidelity bonding requirements, which do apply to group health plans also, and then also important information, fact sheets about our voluntary fiduciary correction programs and our delinquent filer programs that are available, the calculator, etc. So I'm hoping that's something that you'll find helpful. And in addition to that, I've made a list of the publications. I've given you our website, and these are the publications that are on there. And this is the list, but an employer's guide to group health continuation coverage under COBRA is extremely helpful. I recommend everything in that except when it talks about coordination with Medicare. And if there are situations involving coordination with Medicare, Medicare due to age 65, not disability, I recommend that you call a benefits advisor to get clarification about that. Compliance Assistance Guide, health benefit coverage under federal law. Information with regards to disability plans. The Meeting the Fiduciary Responsibilities is a very good publication that I highly recommend that you have a copy of. Selecting an auditor that I mentioned, tips for selecting them. One of the things, reporting and disclosure guide for employee benefit plans. One of the things that I wanted to point out to you is that right now we can't really do this, but when we're back in our office and we're not teleworking, and no one obviously has any idea how long that's going to take, but that we can mail publications to you, and we can usually mail publications as many as you like. They ask us to distinguish between whether or not a requester is nonprofit or for-profit, but to my knowledge, an employer has never been denied us sending them publications regardless of the quantity that they've requested. Now, I also haven't had employers abuse that by ordering huge, unreasonable numbers of publications. But in addition to the employer's guide to continuation coverage under COBRA, we also have an employee's guide to continuation coverage under COBRA, and they say virtually the same thing. So you could give them an employer's guide, and that would be just as sufficient. And that could save you a lot of time and trouble if you're dealing with certain kinds of employees or certain kinds of situations. There's also a good publication, Understanding Your Fiduciary Duties, under a group health plan, and the Troubleshooter's Guide to Filing the ERISA Annual Report, which is the 5500 that I mentioned before. So I'm hoping that those are all resources that you'll find helpful. So basically that's what I have for today. I hope this has been an effective, useful tool for you, if you will, and a good use of your time. I appreciate your attention and you're attending this webinar, and I hope that you attend ones in the future as well. And